Hey there, Money Heroes. It's Stephanie, your host and fellow explorer on the Be Your Money Hero podcast. We're diving into the nitty-gritty of personal finance and having real conversations about how money, spirituality, psychology, and our life stories all dance together. This podcast is educational, but I'm not a therapist, and my guests and I cannot offer personalized advice through a podcast. My goal is to create a safe place for you to learn and get curious about yourself and expand the way you've thought about money. So if you're ready, let's dive in. Hey, Money Heroes. So I know that by the time you're listening to this, it's not technically going to be Pride Month anymore, but I really wanted to bring you this guest because she's got a lot of really great information. I've worked with her in the past on some other things, and she has just really good information that I think will be valuable for a lot of my listeners. I have Kaitlyn with me today. Kaitlyn has received her undergrad from the University of Florida and then her Juris Doctor degree from the University of Florida Levin College of Law. Kaitlyn has always been interested in probate proceedings, estate planning, and asset protection. At Gendelman Klimas Edwards in Denver, Kaitlyn practices estate planning, estate administration, and probate litigation. Kaitlyn has presented to the estate planning chapter of the Colorado Bar Association regarding considerations in estate planning for polyamorous relationships. But most recently, she co-presented to the Colorado Judiciary regarding litigation for non-traditional family structures in family law and probate cases. She strives to provide legal representation that is transparent, efficient, and well communicated. Kaitlyn, thanks for being here.
Absolutely. Thank you for having me. I think that the work that you're doing and spreading general information on finance to people who otherwise may not have certain access or resources to it is really important. So I'm really excited to be here today.
And I think that you bring a new flavor to the estate planning world because you are more familiar than I think anyone I've really met in regards to different family structures, polyamorous relationships, and things like that. So that's why I was really excited to have you on and have you as part of the Pride series that we've been doing over the last few weeks. But I'm curious, what brought you to practice law and specifically estate law? What drove you to that?
I do think that I've always been interested in law. I remember watching, even when I was in high school, more highly publicized trials, for example, on TV, and thinking that law was really interesting, and specifically how the same law could be applied two different ways depending on circumstances and facts of a case. And then as far as estate planning goes, when I was in law school, I took a trust and estates class. The professor was amazing and engaging, and he made the class really fun, but the content I found extremely interesting, not only how the estate planning documents are crafted, but what happens on the back end as far as probate, and then using my own ability to communicate with people about more difficult subjects like death. I was interested to see how I might be able to combine what I am good at and what I had learned in law.
I know that law particularly is an area that a lot of people don't really like to put much thought into because there's a lot of anxiety that can surround those. And we're going to dive into some of those things in a little bit. But for a lot of our listeners, they might be familiar with some of the terms and what they mean, but other listeners might not be as familiar. So I'd love to take just a couple of minutes and run through some of the common verbiage and lingo that is used, just so that people can have a better sense of what it means when they're talking about estates or wills or what a will is. Would you mind running through some of those things, those terms that you commonly hear?
Sure. I will go through a few of them. If there are additional terms that you want me to clarify, I'm happy to. We'll start off with a basic, which is a will. A will is just a document that is going to provide for the distribution of your property at death. Not all wills need to go through the probate court, but many do. I think that it's a common misconception that wills can avoid the probate court. In addition to outlining how your property is distributed at your death, wills can also designate guardians for minor children. They can designate your preferences regarding burial or cremation. So they're not just necessarily limited to assets. Similarly, a trust is another commonly used estate planning tool. A trust is going to be, broadly speaking, an arrangement wherein a person holds, manages, and or distributes property for the benefit of another person. So sometimes a trust can outline a specific period of time during which assets should be held. It can outline how assets should be distributed to a beneficiary, and it can also outline certain reasons or caveats that assets should or should not be distributed to a beneficiary. Trusts can avoid the probate court altogether if they are properly drafted and executed. In both a will and a trust, a beneficiary is a person that is designated by a decedent, that is the person who has died, to receive assets or the benefits of certain assets through a trust or a will or assets held in an account or a policy with a financial institution.
So if we were going to change that into kind of a story format, because I know that sometimes it's easier for me, especially, to understand things if I assign a story. So we could always use me. So for example, my husband and I, we would have two separate wills. And in our wills, we would put what happens to the house or what happens to the car and who would be the legal guardians of our kiddos and who the dogs would go to and like all of those different things. And what are some other situations that you've kind of seen that play out? Like maybe if someone's single with no children and maybe they don't have a lot of assets, do they even need a will?
So the answer as to whether or not someone needs a will, to sound like an attorney, is going to be it depends. There are so many specific facts and different factors where it can massively depend on how much in assets you own and who your relatives are. If, for example, you were not married and you did not have children and you did not have much in the way of assets, meaning, for example, you don't own your primary residence, you maybe have $5,000 in a checking account and nothing else, you may not need a will. You can accomplish estate planning preferences through the use of things like beneficiary designations. But ultimately, I would say that meeting with an estate planning attorney does ensure that your assets get where you want to go. If, for example, you're someone who is unmarried and you have a niece and you want to provide for that niece's education in the future, and you have some assets that you want to be set aside, and you want to designate, perhaps your brother to be the individual who manages those assets for your niece's education, particularly if your niece is not, at or above the age of 18, then a will would be beneficial for you to have. Otherwise, your assets would pass through what's called intestacy.
And I've seen you and I had actually had some conversations about someone that I knew whose father did pass away and they did not have a will because they really didn't have a whole lot, but there was a whole fiasco over the car and then the car was stolen and things along that nature too. So I think that if you are ever in doubt, you should certainly talk to someone and get some more information and see what the best way to move forward would be. And I want to make sure we cover some of the other commonly used terms, such as a living will and like a financial power of attorney. Would you touch on those too?
Absolutely. So a living will, generally speaking, is going to be a document that spells out medical treatments that you do or do not want administered to keep you alive and for the duration of time that you want those medical treatments to apply. So, for example, a standard clause in a living will might say something like, if I am in a coma or a vegetative state after the opinion has been given by my attending physician that I am not going to recover, and after the passage of 7 days, I would like administration of breathing and feeding tubes to be stopped. Similarly, the person who might be making that decision for you or communicating that decision to your doctor might be an agent that you have designated through a power of attorney. So a power of attorney can be what is referred to as a general durable or financial power of attorney, or it can be a medical or healthcare power of attorney. And that's just going to be a document that authorizes another person, who is called your agent, to make decisions concerning you or your property. So an agent designated in a financial power of attorney might be using assets in your checking or savings account to pay bills related to your medical care. And a person who is designated as an agent in a healthcare power of attorney might be the person who is specifically communicating to your doctor things like surgery should or should not be done. I would like to airlift this person to another hospital. Or if you have a living will, this person has communicated that they want life prolonging procedures to be stopped. And therefore, that agent is the person who is able to make that decision.
So I'd like to zoom into the healthcare power of attorney for a bit, because I think that this is a particularly important one when it comes to the LGBTQ plus community. What happens if something unexpected happens and you don't have that healthcare power of attorney, particularly if you are in a state maybe like Florida? Will you visit on that just a little bit?
Sure, absolutely. So I can speak to, in the state of Colorado, there is not an individual who is automatically designated to make healthcare decisions for you. In Colorado, it's not automatically your spouse. It is not automatically your child. It is not automatically your doctor. What can happen, though, is when a medical decision needs to be made and you are not awake, alert, or having the capacity to make that decision, doctors might turn to family members who are around, someone who has been at the hospital. Particularly where I have seen this become an issue is when people in the LGBTQ community are in committed relationships where they would prefer that their partner be making medical decisions for them, but they do not have a healthcare power of attorney. When family members show up, potentially family members that have different religious beliefs, different societal beliefs than you, then that person could be the one who ends up making the healthcare decisions for you as opposed to your spouse or your partner. When there are cases where there has been estrangement, so for example, if I was estranged from my family based on my religious beliefs or, based on who I decide to be in a partnership with, I might not want my parents making decisions for me when someone that I am closer to and have been spending more time with and who knows me better, in my opinion, could be making those decisions, like my partner.
It's also important, I think, too, to have your frontline person, your primary agent, but then also a backup. So for example, I might have my partner listed, but if we're driving together to a party and we get in a car accident and we're both unable to make medical decisions, having that backup so that someone who maybe is a little farther related, so maybe a friend that you don't drive with often or something along those lines, to help with that unlikely scenario.
Absolutely. I've definitely seen people name, potentially a partner. I've had people name their neighbor who they are very close with and they believe has a good head on their shoulders and has their best interests at heart. But certainly if you don't update these documents regularly, you could also have a situation in which the first person that you've named passes away or is in a coma or a vegetative state. And you want to make sure that you have a backup listed that you trust that can make those healthcare decisions for you if the initial agent can't.
And I want to say, too, it's important to review those documents that you have in place, whether, probably on an annual basis. What's your recommendation for just making sure that nothing's changed?
I would say that if you have not had any major life changes, and I can touch on what some examples of major life changes might be, then reviewing your estate planning documents every 3 to 5 years is going to be best. If you know that you have had major life changes, and those can be moving to a different state, buying real property, selling real property, having children, getting married, getting divorced, you're definitely going to want to take a look at your estate planning documents because it's highly likely that your preferences have changed.
And not only to take a look at your legal documents, but also the beneficiaries that you have on bank accounts and life insurance policies and retirement accounts and things like that. Because is it correct that when you have a beneficiary listed on an account, so let's say it's a retirement account, you may have something put into a will, but then you have the beneficiary, maybe it's different on that actual account. Which one wins, essentially?
I think that's a very important distinction. Wills are going to cover what's called probate assets, and probate assets are usually assets that you own in your individual capacity, that are not owned as, for example, a joint tenant, um, and assets that you do not have a named beneficiary on. So, if, for example, you have a retirement account and your will says that you wish for 100% of your property to go to your sister, but your retirement account has a named beneficiary, that is your mother, as far as the financial institution is concerned, they are going to pay out to your mother. That is going to be deemed a non-probate asset as long as your mother is living and can and wants to receive those assets. Those are not going to be considered probate assets. So even though you wish for 100% of your assets to go to your sister, the assets that would go to your sister would be assets like checking and savings accounts, potentially real property that you individually owned that was not held as a joint tenant with someone else. Those are going to be the assets that are distributed under the will because those are probate, and assets with beneficiary designations are not.
And I've run into that a couple of times where somebody's listed, an ex-partner as the beneficiary on an account, and they didn't realize they were still on that. So if you ever go through a breakup, make sure that you are revisiting all of those different things, including that old 401k that you might have that you haven't thought about for a while, and just making sure that you have those pieces in place so that if something were to happen, your wishes, your ex doesn't end up with your money.
Yeah. And I litigate those cases all of the time. Whether it was an ex-spouse or an ex-boyfriend, girlfriend, partner, it is very, very hard to go toe-to-toe with not only the ex-partner, but also with the financial institution to try and prove the intent of someone that died. Particularly in the probate court, a lot of things revolve around the intent of someone who is now deceased and can't communicate that intent. So it's very hard to show that even if you were no longer together with that person, that you did not want them to receive those assets, even if you were broken up.
So what are some other misconceptions that you see when it comes to estate planning?
I would say that there are a few common ones. One would be that estate planning is only for the wealthy or for older people. In reality, estate planning is important for anyone who wants to ensure that their wishes are carried out. And that's not only wishes regarding your assets, but also wishes regarding your healthcare decisions, regarding who will be the guardian of any children that you have after you pass. And then also, it's unfortunate, but no one knows when they're going to die. So assuming that you need to wait until you're older to get these documents in line is, it's a fallacy. Anyone can die at any point in time. And so it's important to have your affairs in order. And I think it does provide a sense of security and peace once you do have everything in order, knowing that people that you care about are going to be provided for in the way that you intended, and that decisions are going to be made on your behalf by someone that you really, really trust to make those decisions. And then I think Another common misconception would be that, as we kind of touched on, once you create an estate plan, you're done. That's not necessarily the case. You can sign the documents that say exactly what you want to happen. However, you do usually need to contact financial institutions. Sometimes you need to create deeds on the back end. You need to make sure that your estate plan is funded how you want it to be funded. And lastly, anytime that you need to potentially make updates, marriage, birth, divorce, death, changes in financial status, you're going to need to take another look at your estate plan. It's kind of a living document that needs to be updated.
Because life changes, things happen, and your legal documents need to reflect those changes.
Absolutely.
Now, one of the things that was crazy to me, and I know that I'm a bit of a nerd, but one of the big things for me when I left my parents' house was actually to get those legal documents in place, because I knew that if something happened, my parents would try to do something, and I didn't want them making those decisions for me. But only 10% of the LGBTQ plus community in America even has a will or estate plan, which is a lot lower than the general population, which is still really low, somewhere between 20 to 33%. But what are some of the most common legal challenges do you see facing LGBTQ clients when it comes to estate planning?
I would say that even in this day and age, the recognition of certain relationships and the stigma that might accompany certain relationships is typically going to be one of the biggest problems. You touched on, for example, family acceptance. Your family members potentially not agreeing with your end of life decisions can be a very real problem. Similarly, legally, a lot of relationships still are not recognized to the extent that they really should be. I see a lot of issues with healthcare and financial decisions, families having different opinions on whether or not you should be taken off of life support, and without having something like an advance directive. A living will is one example of an advance directive, but not having something like that in place can ultimately lead to fighting between your partner or between your family members about your care. Another big one I would say is guardianship of one another and of children. Being able to designate a guardian for your minor child, if, for example, you are a single parent, can become really important for people that are in LGBTQ relationships where they want their partner to be able to care for their child, but potentially their family does not agree with them. So I would say that that's definitely a big one. And then common law marriage is something that has been coming up more and more. I know that I personally have been litigating more and more common law marriage claims where the intention of the decedent, the person who's died, is not clear as far as whether or not they intended to be common law married to a partner. And that really creates a lot of ambiguity regarding how their assets are distributed, who is going to be the executor of their estate, and other kind of decisions regarding funerals and end of life services and cremation. Creates a lot of ambiguity for both the partner of the decedent and the family members of the decedent that ultimately can result in very costly litigation.
When I am working with my clients on that more technical piece and putting, whether it's life insurance or other financial tools or pieces into place to help them with that technical part of their planning long term, the wills and estates are something that comes up. And I tell my clients, I was like, this isn't something that you're necessarily doing for yourself, because I run into some resistance of people actually getting it done. And I tell them, this is something that you're doing for your family, because your family might generally get along, but stress and loss and grief has a way of bringing out certain aspects of people that you haven't seen before. And so especially that living will, like when it comes to how many days you want to remain on life support, you are taking all of that pressure off of your family so that they don't even have to try to put mental and emotional energy into that. That's a service that you're doing for your family, is to take that pressure off of them, because that's not an easy decision.
Absolutely. Absolutely. I think I tell people specifically with the living will all the time is that if you have any preference at all, it needs to be clearly outlined, because you don't want a situation where your partner is having to make that decision without your input and has the added stress of being the person who needs to make that decision for you. Even if, for example, you've had conversations about it before. I have people who say, well, I know my family's wishes and we've talked about it before. I don't want to be kept on life support indefinitely. And they know that. Well, they might know that, but what is indefinitely? If your kids are having to decide whether to keep you on life support for 6 months or take you off of life support after 3 days, that causes unnecessary fighting between your family members. And it also just creates so much added stress. And similarly, if we're talking about a last will and testament or a trust, it is very easy for intentions to be convoluted if they are not spelled out very particularly. I cannot tell you how many times I hear, probably on a weekly basis, I can't believe that my family is acting like this, or my siblings and I used to be so close. My father is probably rolling over in his grave to know that everyone is behaving like this. And I don't think necessarily that it's because family members are trying to get one over on one another, but I think it's because without very clearly stated intentions, people believe that they are carrying out the decedent's wishes. They just believe that the way that those should be carried out differs, or they might have had different conversations with the decedent and taken different things away from those conversations to where they feel like they are acting in their father's best interest and what he wanted, but everyone has differing views on what he wanted.
So, to all of the listeners, if you have not put together your wills and living wills and healthcare power of attorneys for yourself, do it for yourself, but also do it for your family. I'm one of those types of people that I felt better knowing that I had those things in place. Joe, on the other hand, it took me a while to get him to actually sit down and think about the details of it all, because it's not always easy, but it's something that is a huge benefit for your family. And so
and on that note, I'll say it's uncomfortable. It's uncomfortable to talk about death. It's uncomfortable to talk about a world in which your family members are still living and you are not. On that note, I think it's really important to find an estate planning attorney that you feel comfortable with, not only discussing your assets, but discussing some of your concerns, whether that be relationships within your family, or concerns, about specifically talking about this kind of thing, because it can be really uncomfortable for a lot of people. I've certainly had clients who have asked me on consultations not to use the word death, or not to use the term passing away, or not to use the term died. And while it can, be a little bit difficult to conduct an estate planning consultation without using those words, it's important to find an attorney who can talk to you in a way that makes you feel really comfortable, so that you can actually get these documents in place and get everything in order.
And these people actually exist, because I know, especially in the LGBTQ community, and if you're in certain states, having these conversations are really vulnerable for everybody. But especially when you're in the LGBTQ community, and finding someone that you can fully trust, where you can even tell someone that you have a partner that you've been with for 15 years, then those are the relationships that are really important, to find somebody that you're comfortable with and who can really see you for the person that you are, and see the whole dynamic within your relationships. Would you be able to share some examples of how those non-marital relationships can be protected through some of those estate planning tools?
Absolutely. Some examples would be guardianship designation forms. If you have children with a past partner, you can designate your current partner to whom you're not married to be guardian for your child if you and the child's other parent were to pass away. There are certainly situations where one parent has passed away, another parent has gotten remarried, and they want to make sure that their long-term partner, even though they're not married, is able to care for their child and provide kind of the same general family life for that child that child's been experiencing for a while, instill the same kind of values that you would want instilled in that child. So I think that's one really good example. Another that we've touched on is always going to be financial and medical powers of attorney. Everyone has people that they know who they are comfortable making financial decisions for them and whom they are comfortable making medical decisions for them. And your relationships to those people are drastically going to differ person to person. So I definitely would say it's important to get those in place if you do have preferences. Beneficiary designations are a really good tool for people who are not married to their partner to get some assets to their partner. Despite the lack of marriage, if you want to make sure that your retirement account gets to your partner, whether or not you're married, you need to have them listed as a beneficiary. And then I would say domestic partnerships and cohabitation agreements are really good agreements to have in place currently while you are alive, to kind of designate your relationship and lay out who owns what and what should be considered each person's asset. They do also really come in handy on the other side of death, where common law marriage claims are being disputed, because domestic partnership agreements and cohabitation agreements kind of clearly outline exactly what you believe your relationship to be at the time of signing. It can clear up a lot of intentions on the back end.
So if someone is common law married, do they have to go through the divorce process?
So yes, there are common law marriage cases throughout family law where people, when they are splitting up, claim that they are getting divorced because they were at one time common law married. Similar situation in probate proceedings is, well, we were common law married and we agreed upon that. And when we separated, we did not, in fact, have a divorce. Our assets were never dealt with. It definitely, yes, you can go through a divorce with a common law marriage. Absolutely.
And that's probably a whole nother podcast, so we won't go down that rabbit hole too.
Absolutely is. And that is an ever-changing area of law. Most recently, a few years ago, there was case law that clarified common law marriage. Previously, it was set out on a specific number of factors that really kind of only applied to a traditional family. And more recently, the most recent case kind of backpedals on that and says, well, hey, because we have relationships that are not traditional nowadays, particularly because gay people can get married, we need to clarify that a lot of the factors that we previously laid out, for example, publicly stating that you are married to friends and family, that might not apply to individuals who are common law married in same-sex relationships because maybe they don't want to be public about that information. Maybe a large wedding ceremony was not held. The newer case law kind of suggests that it is a large overview of different factors and that a lot of different factors should be applied to specific cases. It's kind of more of the court will know marriage and the intent to be married when it sees it, not necessarily based on these specific assets that we laid out in the past, which kind of only relate to more traditional family structures.
Interesting.
Yeah.
So when it comes to steps that people should actually take to make sure that their medical and their end of life wishes are being respected, what's kind of that first step?
The very first step is going to be having them written down in a clear and concise way and executed according to whatever the execution requirements are. If you need to have a financial and medical power of attorney notarized, you need to get that notarized. If you have a will that needs to be signed by two uninterested witnesses, if you do not have it notarized, you need to make sure that it's signed by two uninterested witnesses or that it's notarized. I would really say what is a little bit more nebulous would be that you need to talk about them. If you want your medical and end of life wishes respected and you are comfortable talking about those with your agents, with your future trustees and personal representatives, you should absolutely do that so that your intentions are clear and so that they feel comfortable making decisions on your behalf. You should give a copy of your executed documents to your trustee, personal representative, to your agent. You can give copies to your financial advisors if you are comfortable doing that. And you also should talk about this with your family if you're comfortable doing so. If you know, for example, that your partner might have to make a very tough medical decision for you, and you know that your family is not going to be on board. If you are in contact with your family and if you are comfortable speaking with your family about that to kind of give them a heads up, that can smooth things over. It's certainly not necessary, but it can result in less litigation on the back end. I think ultimately a lot of this planning is designed to give peace of mind, not only to you, but as you, Stephanie, touched on, to your loved ones and make things easier on them when you're incapacitated or after you've passed. And one of the ways to do that is to be very clear in your communication with whoever your decisions are going to affect, if you are able to communicate with your loved ones about that.
So if someone doesn't have the funds maybe right now for an estate attorney, what would be the next best thing?
So I love this question because I feel like a lot of people automatically default to online forms and online softwares. I realize that I am biased because I am an attorney, but I genuinely believe these forms and these softwares, they're not reliable. Some of these documents can be very well drafted. Some are absolutely not. A lot of them are not reliable. A lot of them are not always clearly outlining your intent. A lot of them have information missing that might be required by state or federal law, or which might be required by a probate court to determine where your estate should be administered. Ultimately, again, you can end up in a situation where there's a lot of litigation that would otherwise be completely unnecessary. While I think that using printed off forms or softwares that you find online can be really risky and kind of dicey, there are other options available. So everywhere that I'm aware of, every state has programs that offer free or low-cost legal services. The Colorado Bar Association website actually has resources for pro bono attorneys where you can go online and find someone who would be willing to do partial or full pro bono estate planning for you or estate administration for you if you're unable to afford an attorney. Similarly, I'll take a second to shout out Metro Volunteer Lawyers. I have done clinics with Metro Volunteer Lawyers in the past, and I know that they do hold them for not only estate planning, but also for family law. Metro Volunteer Lawyers is a connection service that basically connects attorneys who are looking to do pro bono services with individuals who need pro bono services. So when I have done it in the past, I have met with individuals in family law cases and kind of talked them through what needs to be filed next, what the main facts are in their case, what the procedure looks like as they're going through the court. And then on the estate planning side, I have sat down with clients and set up their wills, set up their healthcare directives, set up their living wills with them, had everything signed and notarized before I leave. So I would say Metro Volunteer Lawyers and similar resources are really, really good options.
Thank you for sharing that. Is there anything else that you think that everybody should know about law and the estate law specifically and putting these things into place. Is there anything that you would want to leave our listeners with?
I would leave listeners with a couple of things. The first is going to be that it can be very involved. It can be very overwhelming when you go online and you try to kind of sort through these things yourself, but it doesn't need to be. A lot of firms offer free consultations where you can kind of have all aspects of your estate planning documents explained to you. Similarly, I would say that it's really important, generally speaking, to find an attorney who can explain things to you in a way that you understand. I think a lot of times I talk to people and they say, well, I met with this attorney, but I don't know what any of these documents do. And when I ask questions, they either dismissed me or they explained it in a way that I don't understand. These are your assets that we're talking about. These are your family members. These are your healthcare decisions. And you should have an attorney who is willing to sit with you for 3 hours if necessary and explain these documents and decisions to you in a way that you understand until you fully understand them. I would definitely say that it's important to find an attorney that you really mesh with and who's willing to take the time to communicate to you what needs to be communicated as far as your decisions go.
Perfect. And where would people be able to find you and your firm?
Sure. So I am at Gendelman Klimas Edwards. We are located near downtown in Denver. You can find me on our gendelmanklimas.com website. You can also book consultations directly from the website. And then you can also find me on LinkedIn and doing various appearances and presentations throughout Colorado.
And we'll make sure to have all of those links in the show notes below too. And make sure that you check those out. And as we move into some of these closing questions, Kaitlyn, what does abundance mean to you?
I think abundance to me as an individual means freedom. Freedom to make informed decisions financially and otherwise, and freedom in knowing that you're making the right decisions for yourself. I think as far as estate planning goes, this would be freedom from guilt, worry, stress about your finances or your loved ones, and really freedom knowing that the decisions that are being made for you are being made by someone that you trust.
And what's some of the best advice you've ever received?
I would say 2 pieces of advice. It's one piece of advice from my dad and one from my mom. My dad has always said, when you have to make a big decision, you should gather all of the facts that you can with your head, but then ultimately you need to make the best decision for you with your heart. And inherently, you know what that decision is deep down. I would say that I use that whenever I make big decisions. And then my mom has said ever since I was little and I was going to go and clean my room, but I was stressed. It was too dirty. And even now, up until today, when I call her and I vent to her and say, I am so stressed. I have so much going on at work. I don't even know where to start. Would be, how do you eat an elephant sandwich? One bite at a time. Take one step, take a small step. Whatever your larger goals are, whatever your larger decisions are that need to be made, take it one bite at a time. Take a small first step, take the next step, and before you know it, you've eaten an elephant sandwich.
Thank you so much for sharing that, Kaitlyn. I'm so glad that we were able to get you on the show. The information and the knowledge that you have, there's more than we could even pack into just one podcast. And it gets very individualized. Like there's so much information that you have that comes into play when you're talking about different situations. And so I'm very grateful that you were able to come on the show and share all of that information with us.
Absolutely. Yeah, I'm so happy to be here. And this was great. I'm happy to provide any additional information and review anyone's needs on a case-by-case basis. We do currently have free estate planning consultations for anyone who wants to do estate planning. And then for things like estate administration, guardianships, conservatorships, and family law cases, we are doing a summer special, I guess you could call it, at my firm. Previously, hour-long consultations for those kinds of matters would be $150. Right now, they are free if your consultation takes place in July or August. So would be happy to meet for free and discuss anyone's legal needs.
Thank you, Kaitlyn. As we wrap up this episode of Be Your Money Hero, remember that your financial journey is a path of self-discovery. If you have questions that you would like answered on the show, please submit them to info@beyourmoneyhero.com. If today's conversation resonated with you, share your thoughts and insights with our growing community. Subscribe for more empowering discussions, and always remember, you have the power to be your money hero. Until next time, keep growing, money heroes.